Welcome to Guardians of Innovation, Patent and Trademark Law.
Welcome to Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. I'm your host, Sophia Morales, and in today's episode, we're taking IP 101 for online entrepreneurs, protecting your digital business from day one. So welcome back, Vincent. I'm looking forward to this conversation as well.
Well, thank you. It's always nice to hear your cheerful voice.
Oh, appreciate that. So as an online business owner or thinking about becoming an online business owner, what is the first IP protections you should put in place when you're starting like an e-commerce business?
Well, I think the first thing, again, it's all contractual related. If you're going to prepare a website, chances are you're not doing it yourself, right? You're going to hire
Right.
someone to do it. So let's make sure that you have a right to continue to use it once they filed it, and make sure we have a solid contract that you own the intellectual property. That's probably the first step. We always want to create a name, for our company, and usually people have that already set out. So let's make sure we do a really good search for that name, and let's make sure that it's a strong name. It's not just a descriptor, it's something that's distinctive. And we talked about that in past episodes, the difference between descriptive and generic and suggestive and arbitrary and fanciful marks. Let's make sure we have a strong, distinctive name to start with.
Speaking of distinctive names, one of the first stops is like the eNom or one of these domain registration places. If your name is available as a domain, doesn't that get you some patent protection, or what's the difference between that and like a trademark?
Yeah. So it's clearly not patent because, patent is for a useful article, right? Although there is some patents for computers, it's like a method patent, but we can get to that later. But no, the domain name doesn't protect your name at all. I mean, you have to use a trademark in commerce to gain rights. Now, if Coca-Cola never registered it, and this was a problem, when domain names first came for sale. I don't know if you're old enough to remember,
Oh,
but
yeah.
in my own, in my own mind, at the time, it was like 50, $60 to buy a domain name, and then you had to pay it every year. And in my mind at the time, I was saying to myself, I should get, table.com and book.com and these type of things. And it didn't seem
Right.
like it was, it was almost like gold sitting on the table that anybody could have bought at the time. Put $10,000 up and you could have had, box.com. I think sex.com went for like $8 million like 10 years ago.
Yeah.
I wouldn't be here talking to you right now. I'd probably be on some island that I owned myself if I would have just did what I wanted to do way back then. In order for a trademark, it's a common misunderstanding to think that I register a trademark and I own it. No, that's not how it works. It works that you use the trademark in commerce. I started to say, if Coca-Cola put their name on every single solitary pop machine in every gas station across the world, they would have common law rights in all those cities and all those countries and all those places. But most people aren't Coca-Cola, and you just might have one pop machine in your backyard. So you register it with the federal government or you register it internationally, and people are aware of your trademark. But in order to have a registered trademark in the United States, you have to be actively using it in commerce. So
Mm.
the Constitution gives the federal government power to regulate the citizens of each state through the Commerce Clause. There has to be sales, interstate sales. And when you put it up on the internet, you offer it for sale. Now you're using it in commerce. Without that use, you don't really have any rights to it. I mean, you own that particular trademark, but you've seen so many times where somebody just puts a underscore in the middle of it and it's slightly different and they get the domain name.
Yeah.
There is something called the Anti-Cyber Squatting Act, where if you try to just, cyber squat on Coca-Cola, and the reason it came about is because that's what happened, when these domain names first came to sale. People just got beat to the punch, Coca-Cola and Marilyn Monroe and all these different names were held hostage by people that bought it. But there's the Anti-Cyber Squatting Act, which basically protects you, and it's intertwined with the trademark. And if you can show that you were using it and that somebody went later to get the domain name, just to try to hold you hostage for it, that you can, you can pull that domain name back from them.
Yeah, I remember there were a bunch of cases around that in the early 90s where people were asking hundreds of thousands and millions of dollars for domain names that they just went out and grabbed that they weren't doing any business with.
Exactly. And
Yeah.
and now it's just getting harder and harder because, it's always, my idea of buying all these names would have been great when they first came out, but 30 years later, everything's taken, every combination. And so many, clients come to me and say, every time I think I come up with a new name, I do a search and it's already taken. So it's
Yeah.
getting harder and harder to find. And even, they change domains to have these different .com, .co, .us,
Yeah. That
is,
TV.
because
Yeah.
we're just filling it all up, it's just it's such a difficult thing to do, but owning the domain name itself does not give you rights to use the trademark in commerce.
But it is part of the piece of proving that you're using it in commerce.
Yeah, exactly. I've owned this domain name since this. We put up our website since this date. We've been selling products with the label on the website since this date. Those are all bits and pieces of evidence, but nothing on its own is, well, I shouldn't say that. I mean, everything is important, and who knows what's the most important element and what's not. But when you add it all together, you can, and I always say you have to play Hansel and Gretel, keep a folder in your computer of every time you advertised it somewhere, every document that you did, every web page that you put up. So if there ever has to be a proof of who used it first, you can show that you used it first. And a lot of people don't understand too that trademarks aren't like patents where if you use a patent, a product that you want a patent on in public, you lose the rights if you haven't filed it. Where the trademark is, you actually have to be using it in commerce before they give you the registration because you gain rights by using it. The minute you put up your brick and mortar and you put the sign on it, you put up your domain name and you start selling products with a label on it, you're gaining common law rights. And then you want statutory rights and you want to register those trademarks and you put everybody in the country on constructive notice that it's yours.
Yeah.
Until you send that cease and desist letter, how do you prove that they even knew that you existed? If they're the
Yeah.
store right next to you and they had a sign up the same as yours, I guess it wouldn't be hard to prove that. But if you're in Cheektowaga and they're in Timbuktu, how could they know that you even exist? They
Yeah.
know because you register that trademark. So when people come to me and say, I want to trademark this, well, you've already trademarked it when you used it. The proper vernacular would be, I want to register this trademark, that I
Yeah.
own. I own it now, it's mine. I've been using it in commerce, I have a common law right in it, and I want to register and let everybody in the country know that this is mine.
What's kind of the sweet spot for that? Because it sounds like you do have to do some business in order to get the registration to go through, but there's maybe a moment where you're waiting too long.
Yeah, well, there is something that's called an intent to use application. So even though you haven't used it, you're getting together your marketing, you're signing your lease on your new building, you're preparing your website. You've already done the search and you're pretty sure that it's not going to be there. And I always say it's never 100%. You never know what the patent office is going to find, and you never know if they look at something that they think is confusingly similar when it's not. And we obviously fight those when we think we have a pretty good argument. But you pretty much have a good feeling that it's yours, and you file the intent to use application. Now, usually it takes 5 to 6 or 8 months for the patent office to even look at it. And then it's a couple months after that before you get your certificate. So it's almost like you have a year to start working, towards the marketing of it. Now, if somebody sees that you filed the intent to use application and they go out and start using your mark, if there was an argument, as to who owns that mark, you can use that intent to use application as a date of use. It's called a constructive use. So it wouldn't be fair if you publish your application with this name and somebody else went out and started using it before you, so they would have to prove that they used it prior to the time you filed that application. That's the positive thing about filing an intent to use application. The negative thing, it's not that much more expensive, it calls for you to make another filing at least of a specimen of use at the time that you actually start using it, because they're not going to give you the registration unless that commerce is going on, right? So you'll have 6 months from the date that they allow you. So they'll do their search. They'll say, yeah, we're going to allow this trademark to go through, but now you have to show us how you're using it in commerce. Now, if you're still not using it after those first 6 months, and again, remember we talked about it's taking them 5 or 6 months to get to it, and then
Right.
maybe 2 or 3 months before they even send you the notice. And maybe there's some minor problems with the application they want you to fix that might cost another month or two. So that's giving you a year to a year and a half to start using it from the time that you filed it. But if you're still not using it after that year and a half, you can file an extension of time and ask for another 6 months. And you could ask for 5 extensions. So essentially you get 36 months to do it, but each time that you file an extension, you got to pay an attorney fee to do it, and you have to pay the government fee to do it. So it's a few $100 to do it each time. But once you file your statement of use, then you're done and you get your registration. And then, after that, in between the fifth and the sixth year after you get your registration, you have to prove that you were continually using it for 5 years. So it's not like a domain name where you can just get it and sit on it and not use it. You have to be actively using it or it'll be considered abandoned. So, and then after that, in between the ninth and the 10th year from the time that you filed it, you have to file a renewal, and then every 10 years after that. So if we filed it today or we got the registration today, and in 2030, we would have to file our statement of use and statement of incontestability to show that we were using it in those first 5 years. And then 2034, we'd file a renewal, and then it would be every year after that between 2044 and 45, ad infinitum. So your corporation or your grandkids could always own it. A trademark never dies, whereas a patent is only good for 20 years from the date that you filed it.
Right. Speaking of other forms of legal protection, what is available for, say, your website content, your product descriptions, photos, blog posts, and maybe even the code that runs your calculator?
Yeah, so there is a story about Steve Jobs and Steve Wozniak, who started Apple, right? They didn't have any money when they started. Now Apple's got more money than everybody else, but at the time they didn't have any money for patents. So what they did was register the code as a copyright. So the code is almost like writing a book. It's its own language, right?
Yeah.
So somebody could make their own code to do the same thing, but they'd have to rewrite all the code. The underlying method or what it does is protected by patent. So even if you change the code, but you were doing the same thing, you would be covered by a patent. So the method, the business method of running that software. But the code for your website and the code, all the language that you wrote, that's all copyrightable. Any artwork that you have on it, any pictures, that's copyright. So you own the copyright in there. So if you like pulled up Sony's webpage right now, you would see at the bottom a copyright notice. And there's three elements for a copyright notice: the person's name was Sony, the little C, the circle C, and or
Yeah.
the word copyright C, or the abbreviation COPY, something to that effect, and the date, the year that it is. And sometimes you'll see, well, this website's been up since 1999 to 2005. They might even have a series of years, or a range of years that's been up, and you can actually register your copyright of your website. And the thing is, the website is often changing, and it's never the same. So when you do update it, so it is possible that you could actually register those. And again, it's the same thing. For copyright, you have to you get common law rights as soon as you start using it. As soon as you put it in a tangible form, you own it. And in order to sue somebody for violating your copyright, though, you have to have it registered. So it might be a good idea to register a copyright. And it's a lot less expensive to do a copyright, like I said, than a patent, because it's a simple registration that they don't even do a search. And when it comes down to it, you'll have to prove, again, become Hansel and Gretel, where you saved all this stuff in a file, and you can prove when you did it, and you have it all time stamped, and you can prove that it's yours, because you have to prove that in during the lawsuit. Whereas the patent, they'll do a search to see if it's still new and see if anybody else has done it or anything similar to it that's not confusingly similar, that's obvious, improvement over what's already out there for the patent. For trademark, again, your name that you put on there, that's Sony, that would be your name. And you could put a circle R in association with your name. Now, if you just have common law rights, and I'm not sure if I'm sure they probably filed it. Tim Hortons always fresh. They make a new cup of coffee new pot of coffee every 20 minutes. Every 20 minutes it's always fresh. You might just see the TM next to it. Now, TM says, look, I believe I have a copyright interest in this, and it could be registered, but if it's not registered, you still can put the TM and put people on notice, say this is my trademark. And again, like we talked about before, constructive versus actual notice, right? So it's constructive when you file your trademark, was anybody can go and search and look at and file, and look up your trademark. But it's actual notice if you send them a cease and desist letter, somebody actually sees your trademark and sees it in use, then they know about it, right? So that's why you can use those TM or SM. SM stands for service mark. So if you have a law firm or an accounting practice, you would use SM as your service mark and some people use them interchangeably, but that's the difference. The TM is usually for goods and the SM is for services.
So if you have an online business and you want to protect like some custom developed software code that integrates with a platform that's commercially available, like a WooCommerce or a Shopify, how do you protect that? Can you just go the copyright route there?
Of course, if you come up with your own code and it's unique, there's copyright. But remember, I just said a few minutes ago that the way it works and what it does is patent. So even if you have your own code and you're doing something exactly the way somebody else is doing it and they have a patent, then it's possible you can get sued for infringement. So you need to do a clearance search to make sure that you're not infringing on somebody else's patent or somebody else's, protected intellectual property as far as that goes. So that's when we file patents for these type of things, we don't typically put in code. It's usually an algorithm of all the steps of what's happening. Each particular step. So even if your code is written in a way that accomplishes that code, even if it's unique, you still can get sued for infringement. So I think it's important that you do a search, and when we write it, I always say, is it patentable? Because we're not exactly the same, but are we incorporating some patentable subject matter in our idea? Well, I use this analogy of the pencil. So let's just say, because there's so many parts to Facebook or Spotify or all these different ways they do that, and a lot of them are very similar, like the way people communicate and way that it works. And some parts of it are patentable and some parts aren't. So a patent doesn't give you a right to make something. A patent gives you a right to stop others from making it. So if you invent the pencil and you're the first cave woman to learn how to write with a pencil and you put it together, and I work at Eberhard Rubber, and I learned that this piece of rubber works really good at an eraser because I'm making all kinds of mistakes with your pencil, and I get the patent for the eraser, and somebody else buys your pencil and my eraser and they put it together, and they work at a sheet metal place and they make a pencil with the eraser. Now they have a patent with the pencil with the eraser, but they can't make pencils because you have the patent on the pencil, and they can't make erasers because I have the patent on the eraser. But neither could we. We can't make pencils with erasers, and because I can't make pencils and you can't make erasers. So what happens? Cross licensing, or you just buy your pencils, or the person that invents the patent for the pencil with the eraser buys the pencils from you and the erasers from me and then puts them together and sells them. There's different ways around it, but the whole concept there is, even though you put something together that's unique, your new Facebook, Spotify, Twitter account, if there's elements in there that are patentable, it's possible that you're going to get sued for infringement. So that just the fact that you got a patent for what you did doesn't necessarily mean that you're safe. So it's very important to do the search and make that determination what is patentable and what's not, and try to design around it so you're not infringing on that product.
So, kind of as a wrap up here, for online businesses expanding globally, what do they need to know about protecting their intellectual property across borders and in other marketplaces, whether it's a copyright, a trademark, or an actual patent?
Well, first thing, if you're expanding and you're making that much money, God bless you. If you're an independent inventor that just came up with this idea and haven't made one penny, then you're probably not going to be able to afford to do that, right? You got to be selling it, right? If you get a patent in Europe, let's say France or some other country, they're going to want you to start paying maintenance fees right from the get-go.
Yeah.
The US makes you pay maintenance fees on the 4th, the 8th, and the 12th year after you get the patent. The other countries in the world make you pay maintenance fees from day one, after that first year from the date that you filed it. And I had one client out of Houston, they were a big corporate client, and they had, I think it was the 17th year, and they had 7 European patents, and the maintenance fee was $17,000. If you're not making any money, then 17,000 if you're making millions isn't a big deal, right? With 17,000 if you're not making anything you can't afford to do it, right? And then for each country, I say for patents and trademarks, it's probably at least 2,000 per just to file it, and then you have to make the maintenance fees. So there is something called a PCT application for patents, where it gives you 30 months to file in different countries after you filed your patent. So usually when you file a patent application, you'll get a foreign filing license. It'll give you 1 year to file in any other country in the world, because there's basically a treaty amongst all the the industrialized countries in the world that says we understand that you can't file in everybody's country on day one. So if you file in your home country, we'll all grant licenses to give you a year to file in our country. And a year flies by, as you know, in a blink of an eye.
Really fast.
I always say the years fly by like seconds, and the moments take eternities. I feel like I've been sitting in front of this bright light forever right now, and I've just been here for 15 minutes. But the year will fly by, and we're like, I can't believe we've done 57 podcasts. Where did it go? So that year is just going to fly by. So you can file the PCT application. I'll give you another 18 months. And that's not exactly for every country. Some countries are different, but generally speaking, you'll get 30 months to decide where you want to go. So that'll give you 30 months, kind of like the provisional patent application, to go out there and just see if you can get a return on your investment. I always say, look, if you're going to be on QVC in Germany next Tuesday, let's file in Germany. But if you're not, my advice to the independent inventor is you can't afford this.
Excellent. Well, thank you so much for sharing your wisdom with us today.
Well, thank you for interviewing me. It's always a pleasure working with you.
Thank you. And thanks to all of you for joining us on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. Visit lotempiolaw.com to get in touch with Vincent and the team, and make sure you like and subscribe.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.